Hello, my name is Maxwell Martin, and welcome to my presentation for the Legal Entanglement project that we've been doing throughout aviation law. This project explores the impact of overturning the Chevron deference and its impacts on aviation law. We're going to talk about the implications of the Supreme Court's decision and its significance in the aviation industry. The overturning of the Chevron deference marked a substantial change in administrative law. This affects industries like aviation, where the FAA has long been the leading authority when it comes to lawmaking. The FAA has heavily relied on the Chevron deference to be able to enforce aviation safety standards and issue airworthiness directives and oversee maintenance regulations without having the judicial courts involved. Some key implications are going to be a shift in the responsibility to the courts. As stated before, the FAA has been kind of the say all when anything aviation involved. So we're going to increase some judicial oversight, and that's going to alter the balance between the courts and the regulatory agencies, aka the FAA. The impact on aviation could be potentially having instability within the FAA and increased compliance costs all the way across the aviation industry. So we're going to talk about the Chevron deference and the framework it established for agency interpretation of laws. It was established by Chevron USA versus the NRDC in 1984. The framework of it, the courts assess if Congress's intent is clear. If unclear, courts defer to the agency interpretation if it is reasonable. The FAA has used Chevron deference to maintain aviation standards efficiently, as I talked about before. So I'm going to highlight some of the importances and challenges of this overturning. Some benefits for the FAA include stability in regulations. When we talk about the stability in regulations, we'll have both the courts and the FAA involved instead of just the FAA. You can have an adaptation to technological changes, and some criticisms include the perceived excessive agency power and lack of accountability with the FAA. This is before the deference was overturned, mind you. Now, we're going to talk about Looper Bright Enterprises versus Raimondo. This is where the courts rejected the Chevron deference, asserting the statutory interpretation it's and ultimately the judiciary's responsibilities. In 2023, the Supreme Court's decision was overturning the Chevron deference. Courts now have primary responsibility for statutory interpretations. This is going to lead and has led to significant implications for FAA regulations. Remember before, with the Chevron deference, FAA relied on the deference to be able to be the hear all, say all when it comes to anything aviation. This new standard of approach is going to recognize agencies like the FAA for their expertise, but it's going to be hard to manage the complex technical and specific challenges without the FAA for the courts. So, we're going to talk about now the supporters of this change from the Chevron deference. A lot of the supporters believe that the decision reduces overreach and promotes transparency. So let's talk about their arguments. They ensure adherence to congressional intent. Now, what this means is you will have more of an oversight and more people looking at what the FAA is trying to pass rather than just the FAA passing it. Now, this is leads directly into reducing the agency's overreach, which agency we are talking about for aviation, the FAA. And it's going to benefit smaller aviation businesses. A lot of the small business workers struggle with the multifaceted and at times confusing FAA regulations, and now shifting to a bench could create a better regulatory environment for them. A lot of the supporters back this as a chance to resolve contradictions in agency rulemaking, which it is. It's having more eyes looking at it, and it's not just a hear all say all for whoever's making the regulations. It's an important mechanism to ensure that actions are carefully examined and kept in check. Now, critics argue that the courts lack technical expertise, and that leads to inconsistent rulings and increased legal risks. Now, here's why that matters. Lacking technical expertise, you can't just make a ruling when it comes to aviation. You don't want someone that's sitting on a bench that may know, X, Y, and Z about the shipping industry, but they have no expertise about the aviation industry. You also risk an inconsistent rulings. So before, a lot of everyone who knows aviation would rule in favor of certain things and certain changes. But now, if you have different benches for different rulings, you risk this inconsistency. And also, there is a chance of increased litigation and compliance costs for changes that are made from this deference changing. Now, and also legal disputes between it. Because it's more in the courts, everything is going to cost more. So if the FAA doesn't agree with a ruling, now it's going back into the courts, and that's going to cost the FAA and the courts money. In particular, smaller operators might find it difficult to handle these additional expenses, potentially stifling innovation and limiting investments in safety improvements, for an example. Now, ways to we'll hop back and kind of talk about ways to kind of help the critics' decision would be the court's hiring of subject matter experts in aviation industries or whatever industry that they're dealing with because of the deference. That would greatly help, and they will have a more consistent ruling. But with that being said, certain people have certain agendas, and you just have to make sure you have the right people in place. Now, the real world challenges of this Loop or Bright decision include a lot of regulatory uncertainty. Impacts include uncertainty in regulations, disruptions for businesses that are reliant on FAA guidelines, and again, we'll talk about the increased cost and legal risk for the smaller operators. The decision made from this ruling has immediate compliance repercussions. All the aviation professionals must be ready for a governing landscape where long established rules and regulations can and will be contested or invalidated if the courts don't agree with them. This could, like I said, number three, disrupt and cripple businesses and practices that relied upon years of certain rulings and certain regulations. And if they go in and they change them, they make them stricter for smaller businesses, the smaller businesses won't be able to keep up or they won't be able to afford staying in business. It just has this ruling really highlights the need for industry stakeholders to stay informed and flexible and to adapt to a progressing legal structure, which I think is great for the industry to have more eyes on it, but also it's a learning curve. Now, some proposed solutions, which I kind of touched on earlier, for include some collaboration, congressional clarity, and prioritizing, as always, the FAA has safety and consistency in safety. So, judicial, we really need to rely again for judicial and FAA collaboration, which, again, subject matter experts. Those subject matter experts will clarify statutes through Congress. And again, we really, really, really have to continue to prioritize safety and consistency within rulings. Now, from a biblical perspective, what can we expect? And what can we look at? You can look at Romans 13:1 to let everyone be subject to the governing authorities, for there is no authority except that which God has established. The authorities that exist have been established by God. This really touches on submitting to the government authorities and recognizing that God has put them in place for his order and plan. Another verse we can look at is the collaboration, is to look at the value of collaboration and wise counsel. Proverbs 11:14 talks about the lack of guidance a nation falls, but victory is won through many advisors. Lack of guidance a nation falls relates to the FAA having nobody but themselves. But now, through many advisors, victory is won and aviation industry can continue to be as safe as it has been and safer for the future. We want to put an emphasis on accountability, fairness, and safety, and that's what both of these verses do. And I believe God's plan is when someone in the courts decided to overturn the Chevron deference. Some ethical implications remind us that safety and integrity must remain at the core of aviation practices. It's the aviation industry's responsibility to prioritize safety, to uphold integrity and fairness, and align with biblical values and lawful ideas. As we go through this, some practical recommendations to focus on: training, documentation, advocacy, safety investments, and collaborations that navigate the new legal landscape. Now, we need legal and regulatory training between the courts and I call them subject matter experts. We need more documentation, clear documentation, and continue the investment in safety, and again, strengthen the industry collaboration with the courts. In conclusion, the overturning of Chevron deference brings both challenges and opportunities. A collaborative and ethical approach will ensure safety and fairness. With the overturning of this, we have greater accountabilities and some more challenges, compliance and operational disruptions, which we've talked about, and the path forward, collaboration, safety focus, and biblical principles. Thank you for your attention, and please feel free to ask me any questions about this topic, either through email or messaging through Canvas on Liberty. Have a great day.